My name is Julie, and I'm a senior legal advisor at REDRESS. REDRESS is an international non-governmental organization which is based in London and in The Hague, and we're looking to obtain justice and reparation for torture survivors. Throughout our mandate and work over the past 30 years, we've been working with a very broad range of accountability or quasi-accountability mechanisms. Historically, we have engaged with UN treaty bodies, such as the UN Committee Against Torture, the Committee on Enforced Disappearances, the Committee on Discrimination Against Women, and the Human Rights Committee. We also engage with UN thematic mandates, such as the Special Rapporteur on Torture, but also the Working Group on Enforced Disappearance, the Working Group on Arbitrary Detention, for instance. We support survivors through individual complaints or urgent measures requests. Before the thematic mandates, it's more advocacy-based. So there we're really trying to get those mandates to pronounce themselves on violations, sometimes through letters of allegation or urgent appeals, so that they can make a pronouncement that can later be used by civil society organizations in order to advocate for investigations domestically or for legal change more broadly. We also engage with regional human rights mechanisms. These are the European Court of Human Rights, the Inter-American Court, but also the African Commission on Human and People's Rights. We are also supporting investigations before criminal justice bodies. So we are trying to promote the use of universal jurisdiction in Europe, but not only in Europe, also in other jurisdictions. And we support victims before the International Criminal Court, or we support proceedings themselves through third-party interventions, potentially in the context of reparation, for example, in the Untitled case. And finally, we use targeted human rights sanctions against specific individuals when no other alternatives exist, or to support alternatives when these are further down in time. First up, I would like to say that we always work with national partners, and REDRESS doesn't necessarily always do its documentation of cases by itself. It does it through the national partners that it works with. And the reason for that is that those national partners have the local knowledge, the understanding of the national context. They also have the contacts, they have access, they know the language. And they are able to much more easily approach the survivors and the witnesses that need to be there in order to build a case. On our end, what we do bring is the understanding of the international norms that will guide a documentation process. And we have, with those national partners, in many different contexts, including Sudan, done documentation for many different purposes. Some of them advocacy, some of them in order to approach international forums, and some of them in order to approach accountability mechanisms and advance criminal investigations. And the reason why we do all three rather than trying to do one in a vacuum is because we see them as complementary, and that touches to a question of strategic litigation that we will also touch on later. I'd like first to define what we mean by strategic litigation at REDRESS. What we mean is that when we agree to take on a case or a situation forward, we are thinking about the broader set of issues that can be influenced through the justice process, be they legal changes or social changes, or broader than that. I think that a very good example of strategic litigation is probably the Hissène Habré case in Chad. So Hissène Habré was the former Chadian dictator. It's a case that we are currently still working on at REDRESS. Historically, many organizations have been working on that. But why I'm talking about this case is because it's probably the archetype example of strategic litigation. In that case, Hissène Habré committed many crimes in the 1980s in Chad. He's the former Chadian president. He subsequently fled to Senegal, and it took survivor mobilization, a very wide range of national and international NGOs, very committed Chadian and international lawyers to lead litigation in many different contexts in order to move the dial forward on many different issues. Why was this case strategic? Not only because of the position of his position, Hissène Habré's position as the former president of Chad. So it's very symbolic of what happened in the conflict in Chad, but also because of some of the legal issues that were raised by pushing for him to be prosecuted, issues of immunities, issues of a foreign jurisdiction applying their criminal jurisdiction over that person for crimes committed abroad, so in Chad, on Chadian people. So Senegalese court didn't necessarily weren't necessarily the natural forum for criminal trial of Hissène Habré. All of those actors that I just mentioned had to bring a case to the UN Committee Against Torture against the Senegal state for its failure to abide by the Torture Convention, failure to extradite or prosecute. The Belgian authorities were advocated towards to bring a case before the International Court of Justice against Senegal for him to either be prosecuted or extradited towards a state which could and would be willing to exercise its competence, its jurisdiction. There was litigation before the ECOWAS Court of Justice, then the creation of a hybrid tribunal in Senegal, which ultimately led to the conviction of Hissène Habré and through reparation being ordered for thousands of victims who were civil parties to this case. In parallel, some criminal trials of some of his cronies happened in Chad and also resulted in conviction and reparation being ordered. Now we are still fighting for reparation to actually be issued in that specific case, and we are litigating before the African Commission on Human Rights against the Chadian state for its failure to provide reparation to the victims. So while this case is symbolic, illustrative, is often cited as a large success, which it is, and it meant a lot to the victims that convictions were achieved. It should not be minimized. Reparations still have not been delivered. So this shows one of the major challenges, which is this needs an awful lot of time and resources and for mobilization, for coordination, for court proceedings. It is something that is really, it's a battle that is really being run on a very, very long term. And that's one major challenge. Another challenge that we've observed there and that we've observed in many other contexts is, well, survivor and victim communities, they are not all the better with time. In fact, they get very discouraged by the lack of advancement. So it's really important to reflect to them all of the challenges that we may face in the struggle towards justice and reparation. And their basic needs need to also be met in order for them to be in a position to continue advocating if that is their wish to do so. And finally, we need to leave the survivors at the center of the litigation process. And so survivors' priorities may shift very much over time. and our strategy in the litigation process needs to adapt to those needs. On my end, what gives me hope is really the resilience and the strength of all of the national partners with whom we work, the strength and resilience of the survivor and victims communities as well. So I take a lot of energy from that. But also the fact that I can see often when interacting in these environments that art, creativity, and beauty can grow back from the ashes of atrocities and an armed conflict. And so that gives hope and forward-looking vision.